in a typical franchise agreement, how many pages are there?
It could be in excess of 60 to 100 pages.
So when you don't hear news from them, it's good news. Welcome to the Franchise Formula. My name is Kareen, and together with you, we are going to explore exciting opportunities in the world of franchising. And today we are talking legal with Audrey, intellectual property lawyer.
Hi. So my name is Audrey, and I'm an IP lawyer. I've been doing this in IP practice for 10 years. And my day-to-day basically involves advising clients on their brand strategies, commercialization of IP, franchise agreements, you name it, anything to do with brands, that's what I do.
That sounds like a lot. Actually, so it's because I'm actually very new to that topic, especially legal. Audrey, could you tell me a little bit about what's the difference between a franchise agreement and a license agreement?
Well, essentially, a franchise agreement is a type of a license agreement. So to put it very simply, a license is a consent to use. So if I say you can do so and so, it's basically me giving you a license to say you can do so and so. A franchise, on the other hand, is a lot more structured because it's not just saying I give you the right to do something, but it's also you must do something within certain parameters. You must do it in a certain way that I tell you to, which is why you see franchises around the world looking very much homogeneous, basically.
I see. So that means license agreement, and within license agreement, a subset of it is franchise
that's right.
agreement. I see. So you deal with franchise agreements with the franchisors and franchisees. So both sides.
That's right. Yeah.
So you see both sides to the story as well.
Correct. That's right. Yeah.
I see. So for a typical franchise agreement for franchisees, if I am actually very new, are there any things that I need to take note of before signing, assuming that I'm all ready to put my money in?
Yes, definitely. First of all, a draft contract is usually sent to you to have a look and to decide whether you're fine with the terms. So that's when we look at the terms closely for the client and advise them whether certain things are in their favor or not in their favor, anything that you can try and negotiate. So some of the key terms that I would focus on would be things like developmental rights.
What is developmental right?
So that's essentially your right to operate the franchise, whether it's a single unit, multiple unit, whether you have a right to start franchise. So for instance, if let's say the term says you have to operate 3 outlets within 3 years, then it boils down to whether you can start franchise it to outsource, the work to somebody else to do it for you, or do you yourself have to undertake that in the 3 years, all the outlets have to be operated by you.
Okay.
So that's one of the things that's quite crucial, because then you need to ensure that you have enough capital to run all these outlets.
Okay.
The other thing also would be the term of the lease, term of the franchise rather. And this is something that is quite unique to the Singapore market as well, because usually, let's say if you were to take up a lease for a franchise for, say, a gym, a F&B outlet, the term of the leases in Singapore are usually 3 plus 3 years, which means you have the right to take 3 years and the right to renew for another 3 years.
Or is this like the standard term?
It's quite common in Singapore. So if, let's say, the franchisor who is not a Singapore company, maybe they're overseas and they say, I'm going to give you the right to operate for 4 years, then you have to say things, or you have to push back and say, hey, hang on, usually we have the right to do 3 plus 3 over here. So I would prefer a 6-year type of a runway. Otherwise, it becomes, I take 6 years, but my franchise is only for 4 years.
And then what do I do with the remaining 2 years?
That's right, yeah.
Oh,
yeah.
Okay.
And also then that comes back to whether you can terminate the franchise whenever you want to, because let's say it's a 6-year period, but you may, after the 3 years, you decide that it's enough for you. Then you have to think about things like whether you want to say, if I give you notice, then I can terminate the franchise. But always remember that whatever generally you ask your franchisor for, they will say, okay, let's make it reciprocal. So that means whatever you want, I'll give it to you, but you have to give me the same right. So it's an equal right, right? And the problem with that kind of thing is if I want the right to be able to terminate in 30 days, for instance, then they will also want the same right. And then that becomes very uncertain for you as a franchisee, because anytime the franchisor can say, I'm giving you notice for 30 days.
Oh,
right?
and imagine if you have lease for like the
Correct.
next 3 years, and what do you do with
That's
it?
right. So whatever you ask your franchisor, always be careful because be aware that they might ask for something in return.
Is there like a standard agreement that a franchise business would have?
Usually the franchisors would be sophisticated enough to have come up with a template and they come up with like a master template and then they go to different countries and when they find their franchisees, what they will do is before even sending it to a franchisee, they would localize it. So for instance, something like a term in Singapore may not work in somewhere in Japan. It might be completely prohibited. So they would usually localize it for that country first, then pass on the draft to the franchisee when they secure one.
I see. Earlier on, you mentioned that in the agreement, besides looking at the terms, we also have to look at development. So in terms of development, like for example, they ask of the franchisee, the franchisor asks of the franchisee to say, okay, within 3 years, you have to open 3 outlets. What if I meet with a capital, like a cash flow problem, and I'm unable to do that? And typically, what's the consequence of that?
Okay, so strictly speaking, if that's something you have put pen to paper already, then you would be in breach of an obligation. But there's nothing to stop you from going to the franchisor before that actually happens to say, hey, I'm facing some trouble. Can we renegotiate these terms? So open communication with your franchisor is very important. A good, healthy relationship as well. So if they do value you as a franchisee, they would see that maybe this is a blimp in the road where if they come and help you, there are more long-term benefits for both parties as opposed to saying, oh, you're not able to meet your obligations right now, I'm going to terminate immediately. Because by that time, both parties would have been quite involved and invested in the franchise.
Yeah.
But strictly speaking, if they were to say that you breached the agreement because you didn't set up the 3 outlets in 3 years, they are entitled to do so, which is why it's very important to think about whether that something is feasible to you, even before deciding to commit to that.
That is actually very difficult, right? Because if I am a first-time franchisee, how would I know if I would be able to project my earnings to be able to cover all of these, especially like maybe at this point in time, I do not have the capital, the capital yet, right? So how do you usually advise?
So that would, on that part, it's commercial because usually, I think most franchisees may already have some kind of a track record where they have other various brands that they've managed. But one way to manage this is to have the right to start franchise. So which means that if you yourself, you feel like, oh, there's a lot of capital involved in setting up 2 outlets, and I need some help, then negotiate for the right to start franchise so that you actually outsource the right to another party to say that, hey, do this work for me, but I will make sure I will take the responsibility for you to meet all the obligations that my franchisor imposed on me. So in that way, that somebody else helps you to run that outlet.
Oh, so then somebody else can help you with the capital as well.
Yeah.
I see. So that's tip number 1 that we learned. Okay. So are these 2 the only ones, like the development and the term lease? Are these the terms that usually first time or inexperienced franchisees miss out on? Or are there other things as well?
There are a number of other key clauses to note, but I think one that is very unique to the franchise agreement is probably things like operation manuals or very structured regulations that the franchisor would ask you to abide by, which is kind of why you see the likes of, say, 7-Eleven and McDonald's. It's a very homogeneous look all around the world.
Oh, yes.
It looks like they were in every other country as if they went in there themselves. But what they actually do is come up with a very strict operation manual with things like, you have to wear my uniform, you have to use these colors are in these Pantone shades, you have to serve food of this certain quality, take stock from certain suppliers. So on the point of suppliers, if let's say the franchise is known for, say, a very special item that everyone knows them for instance, like Japanese sweet potato, right?
Okay.
Then the franchisor may say, I need you to buy the sweet potato from my Japanese supplier only. So that's something that franchisees will also need to consider for their bottom line, because it's obviously going to be a lot more expensive to need to import sweet potato from Japan as opposed to Singapore. So that's something you do need to consider. And one way to manage that, because if they're known for that, then you do want that stamp of quality and to be able to say it's from Japan.
Yeah.
Possibly negotiate things like trade price, so that helps you manage your own cash flow.
So negotiate for a trade price. This is also important.
Yeah, especially if there are specific suppliers that your franchisor says you must get it from. Yeah.
Okay, wow, that's actually a lot.
Yeah.
Yeah. So in a typical franchise agreement, how many pages are there?
It could be in excess of 60 to 100 pages, depending on how strict your franchisor is. I mean, I think the more uniform you see a certain brand around the world, then the more you know that somebody in the corporate HQ is telling them that they must abide by certain things. And that's why it looks seamless around the world. Yeah.
Wow. In your personal opinion, do you think that it is easier for a new franchisee to invest in a brand that is already so established with like 100-pager, franchise agreement and everything is set in stone already, or invest in a new franchisor who just started out in doing their franchise business also?
So I think it really boils down to the relationship and probably what you are looking for in a franchise. If you want something that's been there, done that, won't fail. For instance, if you take up a 7-Eleven, you follow the rules where they say you need to set up at a place where your footfall is so and so. Then you know that when you do actually set up a 7-Eleven and say in an MRT station, there will be countless people moving in and out. And in that sense, that manages how much you may be able to earn on a daily basis. If you take up a franchise from a new franchisor, on the other hand, you may have a lot more room to negotiate certain terms because they are as new as you.
Yeah.
But at the same time, that could also mean that there isn't that much goodwill, there isn't much structure where you may not be able to say, oh, my franchisor didn't teach, they couldn't train me to understand certain things or carry out certain things that would have been successful otherwise. So I think it boils down to your own risk appetite, whether you believe in a brand. I think that is something that franchisees need to actually believe what they're selling in or selling to the consumer. So if you want something that's tried and tested, they have a good track record.
Lower risk appetite,
or you know that they ultimately, if something messes up, they would come in and ensure that their own brand, like the goodwill, is not compromised because they're such a big brand.
Yeah.
Then a bigger franchisor might be something that you're considering. But the downside of that is they probably have everything set in stone.
So you just need to follow.
Correct. And if you say, can I push back on this because I don't really agree with this, it's very likely they will say, no, you can't. And then you kind of have to take it as it is. Yeah.
Whereas on the other hand, if it's a new franchisor, you probably have more room for negotiation.
Because they may want you as much as you want them.
I see. So you've worked with both sides and that's why you have come to this conclusion about.
Yeah, you see both sides where negotiations take place where I know if I'm on one side, on the franchisor side, I can say, no, I don't agree. Or if I'm on the franchisee side, I say, please try, let's compromise on certain things. And you have to find a way to negotiate those terms because usually the franchisor is someone who's really sophisticated, they have everything set in stone, but you have to find ways to persuade them to see your side of the story. So I think if I can jump into things like whether a franchisee can advertise or decide that they want to run certain projects or something on their own, one of the ways to actually put forth the negotiations is to say that, hey, I'm more familiar with the local climate, with the local market. Like say for instance in Singapore, McDonald's, right?
Or Subway, for example.
Yeah. So for instance, they might do things like a nasi lemak burger or like a chili crab sandwich of sorts. Yeah, where it's not something that corporate HQ in the US is going to want to do. Or say, please go and do this chili crab or sandwich, right? But it's for the local franchisees to say, hey, I understand the market a bit better, the local palate, the certain occasions, the certain public holidays that drive certain sales and interest. And for me to go and put forth the proposal to say, hey, during these times, I think this would work because I know the place better than you. And so that's a conversation to be had with the franchisor to persuade them to say, please agree to my terms because that's why you're entering into this agreement with me because I know the place better than you do.
So this has to be also in the agreement as well, like for marketing.
Well, usually we would say things like the franchisee can propose certain options subject to the franchisor's approval or parties to agree.
I see. So this is like if you feel that you would want to have your own marketing initiatives as well, also to take note that this clause has to be included.
Yes. You want the right to be able to put forth certain things like to differentiate yourselves from competitors, for instance. Or I mean, there will be marketing things that or promotional activities that they want to roll out globally, and that's why they want to have the right to say that I insist that you do these things. So another example is the recent like McDonald's and Crocs collaboration. I think for Happy Meal, they gave out like the keychain.
Oh yes.
Yeah, so that's something worldwide they rolled out. But you would see in Singapore, you only can find a prosperity burger during Chinese New Year. So it's a compromise. They do their rollouts, their international rollouts, and at the same time, the local outlets have the right to do certain marketing initiatives.
What if, let's say, I'm a franchisee and my franchisor tells me to roll out a marketing initiative that I do not agree and I know that it for sure will not work? Do I have the right to reject and say no?
Well, it's a conversation. So again, it boils back down to how good your relationship is with the franchisors to be able to explain to them like, I don't think this will work because so and so. And then if you have that track record, the existing track record to say that, look at the number of promotional activities that I've run successfully. If you have those statistics, armed with those statistics, then you can say, I don't think this will work because so and so. But if there's a clause in the agreement to say that you must do whatever the franchisor says, then you have to do it. And ultimately, it might be a case of you having to just go with the flow, and then after that, give some sort of a review to say, hey, look at this, it didn't really work, and I mentioned this to you. But open communication, definitely not a blame game type of situation, would be something that helps keep the conversation going.
So what you are driving at is to also have good relationships between the franchisor and franchisee.
Yes.
Not everything is written in legal terms. Not everything is I have to go to a lawyer.
That's right. I mean, I think most relationships are very personal.
Yeah.
So if you are passionate about the brand, I think the franchisor can actually feel it. They can feel like, okay, this person is really going to help me grow that brand. The agreements, however, are equally important because when it comes to a dispute or when parties are no longer friendly, then it boils down to this. And usually from my perspective, we always think about the worst case scenario, really. So which is why your agreements should try to be as watertight as possible, or at least you know or you're aware that these are the pitfalls that you may potentially face down the line before you sign it.
I see. So certain things are in the legal agreement, but I can still maintain a cordial, a very close relationship with my franchisor.
Yes.
And so there would be room for negotiation so that not everything always has to go to Audrey.
I mean, that's right. Sometimes, in fact, when you get their approval, it can be very simple. Like, you just text them and tell them that, hey, you want to do this. And I've heard of instances where there's such a good relationship of trust already that they just say, okay. And it's more of a formality. Rather than having to go through me and I go to their lawyers and say, hey, my client wants to run this marketing program, is that acceptable? Usually after the franchise agreement is done and dusted, the parties tend to negotiate or communicate amongst themselves, unless it becomes ugly again.
I see. So usually after the agreement is done and a relationship is formed, they usually don't come to you unless there are like
any issues or they need to understand how a clause is meant to read.
Okay, so after the relationship is done, just continue to maintain good relationships.
That's right.
So when you don't hear news from them, it's good news.
No news is always good news.
in your case.
Yes, that's right. Yeah.
Okay, so
Yeah.
actually bringing back to the agreement, when things turn ugly, actually I had been really curious about this case in Singapore where this bubble tea brand has learned the operations of the franchisor's bubble tea, and then after that decided to, set up his own brand of bubble tea chains. So that is that a breach of contract, or is there a non-compete clause usually in franchise agreements?
Yes, franchise agreements usually will have non-compete clauses. Basically, as a franchisor, they would want to protect themselves, right?
Yes.
To say that, okay, after our relationship ends, I don't want you competing with me. Especially if it's a relationship that was going on for years, and by which time you know where to get the pearls, where to get the milk for the tea.
I got all your suppliers
Exactly,
ready.
yeah.
Yes.
So franchisors would put that in place, and the period of that kind of a non-compete will depend on, they will put in whatever they want to put in. So it could be 6 months, it could be 1 year, it could be 2 years.
That's reasonable, actually.
So reasonable is a very factual exercise. And if you really need to pin down to what is deemed reasonable, that's something usually you will fight it out in the courts, because
So stressful.
because it's a very factual exercise. Like for instance, you can't put 3 years or something. You can't put 10 years because that's not reasonable. Then you think of how big Singapore, the market is.
Yes.
It's very small actually. So 10 years is crazy. Then you think about how saturated the market is already with those brands. Then you actually put in, you may, if let's say I'm acting for the franchisee and I say 6 months is more than enough, but you are acting for the franchisor and you say it should be 2 years. Then when we fight it out, it's for me to say, hey, I looked at all these other brands and their contracts always say 6 months. So 2 years is way too long. So it becomes a very factual exercise, things based on the geography of the place, how big your market is, how saturated, what's deemed reasonable then. Yeah.
Wow. But all of these, do they have a template? Is it 6 months? 6 months?
I think 6 months would be actually quite a safe period for the franchisee, because honestly 6 months isn't very long.
Yeah.
So I think it's more common to see 1 to 2 years, especially in the F&B market. But yeah, when it comes to maybe a bit more specialized type of services like dentistry or where there's a much higher barrier to entry, then the period of 2-3 years may be too long to stop somebody's to curtail somebody's living entirely.
I see. Yeah. So in that bubble tea, I shall not name, but okay? But in that bubble tea saga, what after that bubble tea saga, was it do you see a trend in more franchisee and franchisors looking at putting more weight on that clause, the non-compete clause?
No, the non-compete clause I think it's traditionally always there. But it's more of how I think the franchisees may want to safeguard their own interests. So for instance, saying that they may carve out, because if you ask the franchisor, please remove this non-compete clause, they would just say no.
Why?
Obviously, why would I do that, right?
Red flag.
Yeah. Why would I do that? I would just find another franchisee. But if you know that that's something that you can't remove, then carve out something that may just help to mitigate that a little bit. So for instance, to say I will not compete within these areas, for instance, in Singapore, then I can still do the rest of the areas. Or I will not compete in relation to, say, for tea, but I can do coffee. So you carve out bits and pieces for yourself if that's something that you see yourself doing in the future. To make sure that it's not so onerous on you when the relationship ends. Yeah.
That's so cool. I feel like lawyers always have this magic to think out of the box. We always think okay, we cannot do tea, means cannot do tea, and then you fight it out on the non-compete clause on not being able to do tea.
Yeah.
But actually, hey, I can do coffee.
Yeah, it's more of finding what works for the client, finding solutions, and I think that's what we like to do.
Interesting. Good tip. Okay, I have also another question. So for example, just now we talked about the lease. So let's say it is a 3+3. So I have a 6-year lease, 6-year franchise agreement. But let's say something happened within my family or personal reasons that I cannot continue. Will there be legal action taken against me? And what are usually the consequences if I were to, say, exit the agreement because I'm unable to fulfill anymore?
Okay, strictly speaking, usually what a franchise agreement would likely say is that you need to be responsible for the fees for the remainder of the term. Yeah.
Okay.
So if let's say you cut short that relationship at say the 3rd year, even though it's a 6-year term, then you would likely need to be responsible for the rest. But
be responsible meaning
like the franchise fees on a monthly basis.
You still need to fork out the money.
Royalties.
Okay.
Usually that's what the franchisor will expect. But in the eyes of the law, the franchisor will need to mitigate their own steps. So in that sense, the franchisor will actually need to go and find another franchisee. They do need to do that. So they can't say, I'm just going to sit back and wait for you to just do everything. And I'm going to sit back and wait for you to pay me everything that should have been paid in that 6-year period. What they do is they need to be able to find or try or look like they've tried to find another franchisee. And if let's say they found a franchisee that is prepared to only pay them $5,000 in royalties, whereas you paid $6,000 in royalties, then you would be responsible for the difference.
So it's on the owners of the franchisor to find another franchisee.
They do need to try and take steps to what we call mitigate those breaches, because they can't just sit back. Yeah. But of course, if they've tried and in the eyes of the court, if this is reasonable, for instance, let's say you have a year that's COVID, right, and nobody is going to take up a new lease or a new franchise. Then if the franchisor can say, I've really tried, but look at these tough times, I wasn't able to, then you would technically be liable for the remainder. Yeah.
But again, if I am in good relationship with my franchisor, I can say, maybe can I pay
That's right. Yeah,
later?
you can always discuss like a payment installment type of arrangement. But usually, in the case of say COVID, there would usually be like a force majeure clause. And that usually means it's an act. Usually they call it act of God, where there are instances and situations that you don't expect. So for instance, like a flood or a tornado of sorts, which is not very common in Singapore, thankfully. But I think because of COVID, that's something that post-COVID, there were a lot of incorporations of such clauses where, they would say things like parties agree to continue the relationship for 3-6 months of sorts. And then after that 3-6 months, parties agree again to negotiate and see how they can take things forward. So there are steps in place. Actually, this is almost protecting the franchisee to say that the franchisor can't just terminate immediately, but they will need to try to negotiate and agree on how they can continue the franchise arrangement when perhaps the government says you can't really operate at all.
Wait, I'm a little bit confused. So meaning prior to COVID, it's always the franchisor saying that, okay, I need to terminate and I can terminate. Is that it?
Well, prior to COVID, I think there was a very catch-all force majeure clause.
Meaning?
To say that in the case of some act of God, like tornadoes or something like that, then parties will agree that they can agree to terminate or they can agree to discuss how to take this forward.
Both parties?
Correct.
Okay.
Yeah. But with COVID, there are now specific in the instance of COVID or in the instance of situations where the government says you can't do so and so, then parties agree that they will discuss how to take things forward. Yeah. So previously it was more catch-all. But because of COVID, I think people are now they have this in mind, the specific situation where there wasn't necessarily a disaster of sorts, but it was a prolonged, when will this end? When will borders reopen? And there's a lot of the uncertainty, and there are specific clauses now that may cover that.
So post-COVID, were there other changes in terms of legal besides this?
I think this was probably the most significant because back then you didn't know whether you could operate in 6 months, in 18 months. We went from DORSCON Red, DORSCON Orange, DORSCON Red. So, so that gave a lot of uncertainty for parties. And as much as the franchisors, I think, didn't want to just terminate the relationship.
Yeah, because there's an existing relationship, right?
Yeah, but there must be a time where if, let's say, this continued even now, there must be some ways for parties to kind of get some closure, move on from there. So I think the ability to operate during COVID was probably something that really now features, I see in franchise agreements more than previous agreements.
Oh, okay. All things legal. I hope you have learned something because I definitely have. Thank you so much for watching this episode, and we hope to catch you at the next episode of The Franchise Formula. Thank you, Audrey!